Hello, welcome to another episode of QuickIP. Today we are talking about copyright infringement, remedies, and defenses. As usual, we start with our map. We've dealt with the first stop, subsistence. We talked about a work. We talked about the fact that there has to be a work within the meaning of the relevant copyright statute. We said the work has to be original. We said the work has to be fixed in a form that it can be perceived, and it has to be authored by a qualified person. And we said that there are specific broad categories of rights that attach to or that are conferred as copyright. And those are the economic rights and the moral rights. And we talked about authorship and who the author is in relation to a given work. We talked about ownership, and the fact that the author is usually the owner of copyright in a work, except where the exceptions we mentioned apply. We talked about transfer and acquisition and transfer of copyright, where we dealt with assignments and we dealt with licenses, we dealt with testamentary disposition as the key ways that copyright can be acquired or transferred. Our stuff today is step 5, where we are dealing with infringement, copyright infringement, copyright remedies for infringement, and defenses to copyright infringement. Remember what we've hammered on previously and what we said that copyright is about, that it is a bundle of exclusive rights, meaning that those rights that we discussed when we talked about the economic rights and the moral rights, when we said the right of reproduction, the right of adaptation, the right of communication to the public, distribution rights, rental rights, importation rights, and so on and so forth, they are held by the copyright owner exclusively. So what it means is that if you're going to use, or no, rather, if you're going to exercise any of those rights, let's say you want to reproduce a work, you want to adapt a work, you want to communicate a work to the public, you need to go to the copyright owner and either obtain a license or an assignment, or one of the ways that we said copyright can be acquired or transferred. And those exclusive rights are held over the specified categories of work, which meets specified prerequisites. This is prerequisites, not prerequisites. Prerequisites. The prerequisite of originality, fixation, the author being a qualified person, and all that. Why did we try to remember the fact that copyright exists in exclusivity? It is that when someone other than the copyright owner engages in an activity that is within the scope of exclusive rights. So let's say you're photocopying a protected work, you are scanning, you're downloading, you're uploading, and you are doing so without the authorization of the copyright owner, then we can say generally that infringement has taken place. So when you look at the copyright statutes in different jurisdictions, you will find that the copyright statute will say that copyright is infringed when someone other than the copyright owner, without the copyright owner's license or authorization or consent, does or causes another person to do any of those acts that are exclusively reserved for the copyright owner. So you already know what the exclusive rights are, or the usual suspects in terms of the exclusive rights. And so if you are going to do anything, let's say you're translating a word from English to Zulu or English to Igbo or whatever, or Zulu to English or whatever language, that means you are adapting the work and you would need the authorization of the copyright owner. That's what I call style 1 of infringement. Style 2 of infringement would be when you import a copyright protected work for a purpose other than for private and domestic use. Now you are an importer or exporter of copyright work, that would be infringing, but just hang on, we'll talk about when those would be infringing. So importation for a purpose other than for private and domestic use, when you're selling, you're letting, you're trading, you're hiring, when you're distributing for trading purposes or for any other purpose that prejudicially affects the interest of the copyright owner. And if you do any of these things, knowing that what you're doing constitutes, or the making of the article that you're importing, the making of the copyright work that you're importing or selling or distributing constituted infringement, or would have constituted infringement if it was made in the specific jurisdiction. When that happens, so you have to establish that knowledge element in style 2. There has to be the fact that the person who is doing the importation and selling and distributing knows that the making of that article. So let's give a typical example. Let's say you are importing books, pirated books, or books that are, let's say, let's give an example. Let's say in a given work by a, let's say, what's a good example? Let's say Bridgerton, the Bridgerton series by Julia Quinn. Let's say there's a jurisdiction where it's being photocopied. Let's say in South Africa, for example, it's being photocopied and bound, and then someone is importing it into another country. You know that the photocopying of that work in South Africa is infringement, right? And then someone else is importing those photocopied copies, which, you know, constituted an infringement, you know, if it was made in that country, or even while it's being made in South Africa. There's also infringement which could be criminal infringement. Infringement could attract criminal liability. And criminal liability usually happens when the state, the relevant prosecuting authority in a given jurisdiction, decides to prosecute one for style 2 infringement. Now, infringement has taken place. What remedies does the copyright owner have? In many jurisdictions, they would be able to claim for damages for infringement, or they could claim for reasonable royalties, where you are, or they could claim for what we call account of profit. They could claim for what is referred to in South Africa as an interdict, or in other jurisdictions as an injunction, basically stopping the person, the infringer, from further and continued infringement. They could also ask for remedy of having the alleged infringer deliver the infringing copies or plates, you know, whatever machinery used for infringement. Note that in many jurisdictions, including in South Africa, it's usually that you can either ask for damages or for reasonable royalties. You cannot ask for both. So you, as a copyright owner, make a decision or as to which kind of remedy that best suits the particular work or the particular infringing activity. Now, apart from the fact that there's remedies that the copyright owner can rely on, there's also defenses available to the alleged infringer. And this list of defenses, or these defenses, usually go back to the conversations that we've had around subsistence of copyright, ownership of copyright, and the scope of the exclusive rights given to or conferred to the copyright owner. We start with originality. If the work is not original, even though it has been created, even though it has, you know, the copyright owner, no, let's dial back. If a work is not original, even though it's a work within the meaning of the given copyright statute, that work does not enjoy copyright protection. And usually the copyright owner might not readily find out that, because copyright exists without formalities as to registration and all that, refer to previous QuickIP. You would see where we talked about the fact that copyright does not require registration in many jurisdictions to subsist, at least to subsist, but just look at those or listen to those the specific previous QuickIP series. So let's say that the work is not original. That can be a defense that an alleged infringer can offer to say, well, there's no copyright in this work because it's not original. Or they could offer a defense where they are saying this is not a work within the meaning of the Copyright Act. Let's say, for example, you wanted to protect the smell of particular perfume. Maybe you write down the chemical composition of that smell or the scent of a particular perfume or the taste of food. That has happened in the EU, for example, and the courts will say, no, this is not a work within the meaning of the Copyright Act. You could also have as your defense that the person's coming to court, the person taking you to court or trying to sue is not the copyright owner and is not someone that the copyright owner has authorized to do so on their behalf. So you're saying there's no locus standi. Or you could say that even though there's similarity between your work and the copyright owner's work, it's not substantial similarity in there's no substantial similarity in the two works. Or you could be saying, well, I used your work, but what I used your work for, it's outside the scope of your exclusive rights. So it's not reproduction, it's not communication to the public, it's not distribution, it's not, you're basically saying, these are your rights as a copyright owner. I'm well aware of them, but what I have done is outside the scope of your exclusive rights. You could also say, remember we said copyright doesn't last forever, even though it lasts for a very long time. But you could also, as your defense, if you can establish that, say that copyright in this work has expired. There are also general and specific limitations and exceptions within various copyright statutes, and we will deal with those in the next QuickIP. A quick roundup. Remember that copyright grants exclusive rights, and because it's exclusive, you cannot use or exercise those rights without the authorization of the copyright owner. If you do so and you are not able to, if you do so, you would be infringing, and the copyright owner would have recourse to remedies. However, you could successfully plead any of the available defenses, like saying there's no originality or the requirements for copyright subsistence has not been established, or you could be arguing some of the defenses that we've mentioned. We'll stop here and see you in class. Bye.